Well, good afternoon, everyone. The subject of this webinar is uh, holidays and also travel, which are generally speaking very enjoyable subjects to talk about. I'm going to be looking at the impact of the Package Travel Directive, Directive 90/314, and what the proposals are for changing it, what problems have been met with it. I'm also going to talk about the denied boarding regulation 261 of 2004 regulation, and again what's worked with that and what is perhaps in need of some review. So the Package Travel Directive, which has been brought into law in the English jurisdiction by the Package Travel, Package Holidays and Package Tours regulations of 1992, which I shall call the Package Travel Regulations, or the PTRs. To give a very quick overview, they create a lot of protection for consumers who purchase holidays, which are packages, and incidentally business travel is also included if it comes within the definition of a package. But most of the travel involved is leisure travel, of course. Some of the protections which are given to consumers, which I'll deal with quite quickly at this stage, are protection against misdescriptions, misleading words in websites or brochures or leaflets or television advertisements, whatever. Also a list of information which must be given accurately to consumers. Also a limit on the amount which can be surcharged to consumers and their rights to pull out of the contract if too much is surcharged by the travel organizer. And also if there are changes to travel or accommodation arrangements pre or post departure, then those are also regulated under the Package Travel Directive, and rights are given to consumers to have alternative arrangements, usually at no extra cost, or to have a full refund, and in most cases to have compensation on top, unless the change has been brought about by a force majeure situation. So, and there is also, under Article 7 of the directive, the right to have your money protected. In other words, an organizer who sells a package must have in place arrangements to ensure that any prepayments made by consumers are secured in one of a variety of possible ways, including bonding or insurance or a trust account or various other techniques. But the money will be secure in case the tour organizer becomes insolvent. So those are some of the protections, but the major issues under the Package Travel Directive and under our English PTRs come about under two headings: the definition of a package and the question of liability if something goes wrong during the package. The definition of package contained within the directive and reflected in the regulations is as follows: a pre-arranged combination of at least 2 out of 3 of transport, accommodation or other significant tourist services when sold or offered for sale at an inclusive price, and when the service covers a period of more than 24 hours or includes overnight accommodation. The major problem with those words have arisen not so much over the need for there to be transport and accommodation, or transport and other tourist services, or indeed accommodation and other tourist services. For example, entertainment of a substantial nature. The problem has arisen out of the words pre-arranged combination and out of the words inclusive price. Pre-arranged combination, the difficulty with that is it doesn't say what it means. We all know that pre-arranged means arranged before something. But the problem is that nowhere does it say in the directive or in the PTRs arranged before what? Arranged before the consumer ever thinks of approaching the trader, that's one possibility, or arranged before contract, or arranged before departure, that would be quite a late date. The answer has been given by a decision of the European Court of Justice in the case which I can briefly call Club Tour against Garrido, 2002, in which a Portuguese consumer purchased from his local travel agent a stay at a Club Med resort in Greece. And he said to his agent, while you're booking that for me, could you also source me a flight from Portugal to Greece and back? And so Club Tour went out and booked the accommodation, and they also found a flight for Mr. Garrido. When Mr. Garrido got to the resort, he found that it was overrun by wasps. And so, not surprisingly, he wasn't very happy, and not having paid in advance for his holiday, which incidentally is an unthinkable situation which could never arise in the English jurisdiction. But anyway, not having paid in advance for his holiday, he refused to pay for it when he got back home, and when he was sued for it by Club Tour, refused to pay, saying that this was substandard because of the wasps. Club Tour said, we're only an agent, this is not a pre-arranged combination, we put it together for your specific benefit. But the European Court of Justice held that this was a pre-arranged combination because it was put together at the request of the consumer prior to contract. So that disposed of any problems really arising out of the words pre-arranged combination. However, much more chronic and problematic have been the problems arising out of the words inclusive price. This came to a head in the English jurisdiction in a number of recent cases. The case of ABTA, the Association of British Travel Agents, against the Civil Aviation Authority, the CAA, and also the case of the CAA against Travel Republic. And what these cases decided was that inclusive price means this. It's a question of whether the arrangements, the transport, the accommodation and so on, flight, the hotel, whatever it might be, were put together as individual components of a combination, or whether they were offered as separate components which the consumer could take or leave. And it's a necessary implication of that it's made clear to the consumer that he or she can take or leave the elements. So, to give an example, if you want to go to Barcelona for a trip and you're being offered a hotel and a flight, then if he doesn't want to sell a package, it's incumbent upon the travel arranger to say to the consumer, the flight, you can have the flight for £150, you can have the accommodation for £200, you can have either of them or both of them. If you have both of them, you don't get any discount for doing that. You will just mathematically add up the two components. It will be £350 for both of them. And if you don't like either of them, you can buy one from us and go somewhere else to get the other. If that's not done, then basically it's an inclusive price and becomes a package. A useful analogy that's been used is of the supermarket. if you go into a supermarket and you put into your trolley, your shopping trolley, to use a phrase which is also familiar with internet sales, then you take your butter and your bread and your sugar, you put them in the trolley, and when you get to the checkout, you are not asked for anything that could be described as an inclusive price. You are asked for a total price, and so that would not be a package. But where in the supermarket goods are on sale on a special offer, for example, 3 for the price of 2, now that would be an inclusive price. So that's a useful analogy in considering whether a package holiday or package travel arrangements have been sold or not. The Travel Republic case was interesting because Travel Republic sold mostly through their website, and you could select a flight and you knew what price it was, and you could put that in your shopping basket online. You could select a hotel or other services. The same would apply. There were also messages warning you these were not packages, and so the court held that these were not indeed packages. More recently, in fact very recently, in December 2011, the Court of Appeal in England decided a case called Titsall against QWERTY Travel, and in that case, although it was said that the price was broken down, 2 factors made the court decide that this was indeed a package. The factors were, number 1, that this was a sale carried out on a Sunday evening by telephone for a departure the next morning, Monday morning, and so the consumer just wasn't interested in learning about breaking down of prices and going somewhere else to shop. He just wanted to know if he could book a holiday then and there or not. So there was insufficient breaking down of the price for the consumer. And number 2 is there was an indeterminate service charge applied which wasn't properly explained to the consumer, and the Court of Appeal decided that this must be the price of creating a combination or package. So that's the recent authority on definition of package. As far as liability is concerned, liability is defined in terms of liability of the tour organizer for non-performance or improper performance of the obligations under the contract, regardless of whether those services are being provided by the tour organizer himself or by his suppliers and subcontractors. For example, the hotel, the airline, the rail company, the transfer company, the ski shop, whatever elements there may be in the package. So if there is some fault on the part of those people, then the tour organizer is liable to pay compensation. Interesting questions have arisen in our jurisdiction in England as to whether that liability is strict liability or fault liability. And it was decided in a case called Hone against Going Places in 2003 by the Court of Appeal that the liability was fault liability where injuries and illness were the consequence. So if a consumer suffers personal injury whilst on holiday, in order to succeed, he needs to establish that the supplier or subcontractor, the hotel most frequently, was negligent in some ways. And if you can do that, then the tour organizer will be liable to pay compensation for the injuries. If, however, it's a description, for example, the tour organizer has promised that there will be a swimming pool at the hotel, and there isn't a swimming pool, then there's no need for the consumer to prove fault on anybody's part. That is a strict liability promise. There must be a swimming pool, otherwise compensation is payable. So certainly in the English jurisdiction there is that distinction. So that is a very quick view of the Package Travel Directive and the English regulations, and it has indeed created a massive amount of protection for consumers which did not previously exist. However, in 2007 the European Commission decided to review the workings of the Package Travel Directive, driven by the great change in the market, in particular the advent of popular booking of holiday and travel arrangements on the internet, and the advent of the low-cost airlines. Many issues are being reviewed by the Commission. They started, there was a consultation which closed in February 2009, February 2010 I should say. There was a stakeholder forum in April 2010, but since then up to when I'm speaking in January 2012, there has been little news. We're promised something by the end of 2012, but we'll see. Now the review is going to look at a wide range of issues, but the two major issues I just mentioned are at the forefront. The definition of what is a package. There is a desire to bring into the ambit of packages a much wider range of arrangements, including those of the type that I just described in the Travel Republic litigation, where elements may be sold at separate prices, or via a click-through on a website whereby you buy one thing and are then referred to another website, even though you may not be aware that's what's happening, to buy another element separately. There's a desire to capture as much as possible within the rules which protect consumers. It's proving very difficult to write a definition which captures what you want to capture but leaves out what you want to leave out. So that's one area of review, and the other area of review is the liability section. There is talk of introducing strict liability, but that in turn is made more complicated by the fact that in some jurisdictions within the European Union, claims for personal injury cannot be brought for breach of contract. Now, claims under the Package Travel Directive are all contractual, and so in some jurisdictions tour organisers, tour operators and travel agents face claims under the Package Travel Directive, as happens in England, and in some they don't. So the introduction of strict liability would be a very serious consequence for those who face personal injury claims under the Package Travel Directive, and would create a very unlevel playing field within the European Union, something which is generally sought to be avoided. Well, we'll see what happens anyway, so stay tuned to this channel. Some inspiration may be given to the European Commission by some work that's going on in the United Kingdom, because the government here has got fed up of waiting for these changes from Brussels, and has therefore decided to introduce reforms, at least as far as the protection of money, of prepayments are concerned. And so there's going to be a new creature called a Flight Plus in the United Kingdom. And basically, where anyone buys a flight from a trader, whether that's being sold as an agent or as a principal, and within 24 hours either side of that purchase, the consumer requests accommodation or car hire from that trader, then there is created a Flight Plus which must be protected, and this is dealt with under the ATOL, or Air Tour Operators Licensing Regulations of 2012. And the definition there gets around all the problems by omitting any reference to pre-arranged combinations or inclusive price if the elements are booked within the timescale I mentioned, and there's also a wide definition of what the trader needs to do. Merely facilitating the booking is included, so that, for example, click-throughs will be included too. then that may be an inspiration for the European Commission in seeing how they may go forward with a new definition of package. So that's where things stand on that. I want to move on then to Regulation 261 of 2004, which deals with airlines. This is not targeted at tour organisers and tour operators, but at airlines, and it covers denied boarding, it covers cancellation of flights, and it covers delay. And for all those things, there is a menu of remedies for the consumer. In the case of denied boarding and cancellation, compensation is payable depending on the length of the flight and the length of the delay. The compensation will be between €250 per person and €600 per person, although that can be reduced if the delay is very short. When I say delay, I mean delay caused by denied boarding or cancellation, not pure delay on its own. There are also, whether it's denied boarding, whether it's cancellation, or whether it's delay, there is a menu of care arrangements which have to be offered to consumers in terms of providing or paying for accommodation, meals, taxis and so forth to and from the accommodation and the airport while they are waiting to set off on their new travel arrangements. Two things about that, or three things in fact. First of all, what is a cancellation? And in particular, there is an exclusion where there is a force majeure situation from the need to pay compensation. Is technical defect with the aircraft, is that force majeure? Well, a case of the ECJ a couple of years ago, Valentin Herman against Alitalia, made clear that the courts take a very hard line indeed on the definition of force majeure, and airlines will have a very tough job to demonstrate that a technical failing is force majeure. It would have to be an extreme situation indeed. The next question, the second of my three questions, is what's the difference between cancellation and delay? In a case called of the ECJ again a year or two ago, Sturgeon against Condor, this question was broached. The ECJ decided that there is a difference depending, for example, on whether there's a new flight number given and so forth, but they decided it doesn't matter because, notwithstanding the clear wording of the regulation, which only provides for compensation for denied boarding or cancellation, the ECJ said that where the delay is long enough, the compensation, €250 to €600, will similarly be payable to consumers for pure delay. Now that's a very controversial decision. Again, in the English jurisdiction, all claims for compensation for pure delay are currently stayed, pending a reference back to the ECJ to query whether that decision can be correct. But that's how it stands at the moment. The third issue which arises commonly under the denied boarding regulation is that which is thrown into stark relief by the volcanic ash problems of a couple of Easters ago and the closure of European airspace. The result was that many consumers were not able to set off on their journey, and airlines were obliged, although they didn't have to pay compensation because this clearly was a force majeure situation, they were obliged to provide requisite alternatives and refunds and so forth. But what really impacted on the airlines was the problem at the other end of the travel arrangement, where consumers were stuck in their resort or destination and couldn't get back home again, because this meant that airlines were being called upon to pay potentially unlimited amounts of hotel bills and meals and telephone calls and so forth. And this was they felt an extreme burden to carry, um, although there's been quite an amount of small claims type litigation since then to decide whether there are limits on the number of nights, or whether it's 3-star rather than 5-star accommodation and so forth that needs to be paid for. And I think the watchword here is that claims need to be reasonable. Again, the Commission is having a look at whether the regulation is working as intended, whether it's protecting consumers adequately on the one hand, or whether it's punishing airlines in situations which were unforeseen when the regulation was introduced on the other hand. So again, this is early days for that consultation, and we'll see what happens. So there we are, a brief overview of the Package Travel Directive and the protection it gives to consumers and what may happen in the future. A brief look at our new ATOL regulations for Flight Plus in the UK, and a look at the denied boarding regulation and how that's working in practice. And thank you very much for listening.